We're going to talk to Eugene Corcoran, who is the Chief Bureau Officer at CAB, the Criminal Assets Bureau in Ireland. And many law enforcement people regard CAB and its activities as one of the most successful examples in Europe of the possibility to seize criminal assets from people who have committed crimes. So good afternoon to you, sir.
Good afternoon.
Could you just tell us a little bit about the background of how CAB came into existence?
Well, CAB came into existence almost 15 years ago now, in the latter half of 1996, at a particular point in time when, in this jurisdiction, it was felt that criminals and the manner in which they were able to store away the proceeds of their crime had reached the point where something radical was required in order to respond to them. And in particular, there were two events in June of that year, precipitated by the murder of a journalist and by a senior police officer within a short number of weeks of each other, which finally, I think, brought it home to everybody in the country that something radical was required. And as a result, the political response at the time was to establish the Criminal Assets Bureau. And in essence, I suppose the Bureau was unique, and nothing similar to it had been in place in this jurisdiction beforehand. But the Bureau was structured, and is to this day structured, with the police as the head of the Bureau. The Bureau is headed by myself as a police chief superintendent, but it's staffed also by staff of the Revenue Commissioners and of the Department of Social Protection. In addition, we have staff from the State Prosecutor's Office, Chief State Solicitor's Office, and we're assisted by technical staff and analytical staff by way of expert assistance. So the key to the operation and what was radically different about what we did really was we approached the issue of criminal assets in a multidisciplinary way. In other words, that every government department that had some role to play was given an opportunity to work together, whereas in the past each department pursued individuals in their own right, using their own individual legislation. And while some success was achieved, the idea of doing it in unison, where every department works exactly together in a working team, and all of the legislation and provisions that are available to the individual departments can be used in a coordinated way against the criminals. That has been, in the 15 years since our establishment, the key to any real success that we've had.
Now, if we look at, just to make people understand the workings of your Bureau, could you just briefly describe, if we sort of make up a case or if there is something you can talk about, just to describe how this all works? Now we know about the background, but how does it work really?
The most, I suppose, one way to describe it really would be that in cases, for example, where a particular criminal has been identified, I mean, the key to the underlying motive here is the identification and confiscation of criminal assets and the deprivation of those assets from the person, or the deprivation of the benefit of those assets from the individual concerned. So the starting point really is to identify a particular criminal and to take a look at that individual and their entire lifestyle from start to finish. In other words, the task is first and foremost to identify that they have been involved in criminal conduct, that they have in fact made some gains as a result of that, that those gains, whether they be monetary or if they've been converted into property or other valuables, are identifiable in any part of the world. So the task then for each of the sections working together in a team is to take that individual and approach the investigation from the point of view that every aspect of that person's responsibilities to the state are looked at. In other words, their revenue liability, whether they're in receipt of any social payments by way of social welfare protection, or whether they're claiming any other benefits from the state. And then from the police perspective, to investigate the criminal conduct that they've been engaged in. So the key to it really is that the personnel that are engaged in that task do so together, working in the one team, and there's no fragmentation of that approach. It literally is every section applying their own particular role and responsibility in unison, so that at the end of the day, what's achieved is a complete picture of the individual and also of the assets which they've accumulated, which we're able to identify, together with any revenue liabilities and social payments that they're liable to repay.
Now, as for proving if this is a result of the money and property that this person has, if that is a result of criminal activity, is it up to the police and your team to prove it, or is it the other way around, that the suspected criminal has to prove that it's not ill-gotten gains?
Well, one of the advantages of the legislation that was enacted in 1996 was that the traditional proofs that were applied in criminal cases, in other words, and still apply in criminal cases, which are the standard of proof beyond a reasonable doubt, was replaced for the purpose of proceeds of crime with a proof on the balance of probabilities, which is a civil standard of proof applying. And the benefit of that really is that at a particular point in time, having identified criminal assets and having taken a proceeds of crime action to the courts, in the Irish case to the High Court, and at a certain point in the process, the onus shifts to the individual person who is the defendant in the proceedings to establish that the proceeds that are referred to are not in fact the proceeds of crime. So there is an opportunity, while we must establish to the satisfaction of the court what we say are the proceeds of crime, and we must produce the evidence upon which we intend to rely to establish that to the court's satisfaction. There is nonetheless a provision whereby the person must themselves, at a particular point in time, establish to the court's satisfaction, if they're in a position to do so, that in fact the income or proceeds or benefit to which we refer has in fact come from a source that isn't a criminal source, if that's the position.
Now, if we look at the money side of all this, I don't know if you have any figures for 2010, but maybe for 2009. What are the money or properties involved?
Well, there are. I mean, for 2009, for example, our 2010 figures are the nature of this, the nature of the work we do, and the process built into the Proceeds of Crime Act has within it a 7-year process from start to finish. So to produce year-on-year figures quickly can be quite difficult, because a lot of cases that have commenced, let's say, for example, in the current year, may not have a conclusion for 7 years or even a longer period. So, and the second sort of caveat I'd just add in terms of figures is that we have experienced an economic downturn in this country, and that has not left criminal assets unaffected more than any other assets that are available to us. But last year alone, we were in a position to return almost €7 million to the exchequer directly by way of proceeds of crime, revenue and social welfare proceedings.
Was that in 2010 or 9?
2009.
Okay.
The figure for 2010 is similar, but it may be slightly less because of the property values have dropped considerably in this jurisdiction, and a good deal of the proceeds which we ultimately return arise from the sale of properties which we have seized over a period of years. So therefore, it's while we last year, say, was 7 million in net returns, but on top of that, the total proceedings in which the monetary value, potential monetary value, is closer to 20 million in terms of what may ultimately be the benefit arising from the work of 2009, for example, and similarly for 2010, we hope, when that's finally calculated. So it's quite a difficult figure to arrive at for any 1 year, because of the time spans and time limits that are built in to the legislation itself. But regrettably, as I say, in the early years, certainly, of this legislation, the concentration has been on properties owned by criminals, because that was the preferred option for criminal proceeds, was to invest it in property. That has shifted somewhat in more recent times, when other items such as valuables like arts and antiques and possibly properties in other jurisdictions and matters of that kind have been chosen by criminals as a means to dispose of proceeds.
Now, let's say that a criminal has invested money in Spain or in Portugal or elsewhere.
Yeah, well, what's happened, I think, because of the manner in which the legislation operated in the first, say, 8 to 10 years, was that the criminals responded by relocating, and some of the countries chosen were countries like Spain and elsewhere, and the Netherlands, for example. So increasingly our work is concentrated upon cooperation with the authorities in those countries. And we find that we must cooperate practically on a daily or weekly basis at this stage with the authorities in many European countries, because of the shifting trends in criminal conduct as a result.
And the cooperation with other countries, is that a difficult task, or does it work pretty smoothly? Or
we find that we have excellent cooperation with our European neighbours. Some of the issues that arise purely from differences in the legal systems that are historical between the jurisdictions. But in terms of cooperation on investigations and in terms of liaison or direct liaison between the investigative bodies in many countries, we have excellent cooperation, and we use the machinery of the EU, so the asset recovery offices, which have been established under a directive 2007. We're also involved in a network known as the Karen network, which is a worldwide network involved in enhancing cooperation in the area of asset recovery, and find that by participating in those groups and international organizations, that the cooperation is enhanced, and we make the best use possible of all our contacts that are afforded through that exchange.
Now, if any country would like to set up a similar organization as CAB, are there any thoughts that you might provide for them to make sure they don't repeat the possible mistakes that you've made? What would you sort of pinpoint if people would like to set up something similar?
If people were establishing something similar, I would recommend that the period of time within which people are afforded an opportunity to make responses to the court should be short rather than long. Ours is 7 years within which a person may return to the court to bring new evidence to establish that perhaps the case we've brought doesn't, or a defence arises. I think a shorter period of time is preferable, because we've recommended here to our own legislators that 7 years be reduced to something in the region of 2 to 3 years, because we have, from our experience, established that that's sufficient time within which to uncover practically all of the relevant evidence that's necessary in cases of this kind. I would say that also that the one advantage that we seem to have that other similar experiments elsewhere may not have is that the benefits of working closely together and having the personnel from the various units actually physically working together cannot really be overemphasized, because any sort of breakdown in communication or any time delay between transferring requests from one section to another simply adds to the time taken in an overall investigation. So somebody who's in possession of all of the facts that are available to all of the units can contribute, I think, best to the overall investigative effort. But there are many things, I suppose, that we've learned over the years. But in general terms, I think the key to it really is to have a dedicated piece of legislation, have a dedicated unit, and to empower that unit to the maximum extent possible to apply itself to the task of asset recovery.
Okay. We say thank you to the Chief Bureau Officer at the Criminal Assets Bureau in Ireland, Eugene Corcoran. Thank you very much for talking to us.